When it comes to what's happening in Wayne County and the North Carolina area, look no further than Taylor House Publishing. If you have a story that needs to be told, please contact us via email at taylorhousepublishing@gmail.com.
It has been 31 years since a man from Goldsboro was shot, and now 3 decades later, an arrest has been made. Goldsboro police say German Pearsall is charged with killing Gino Harper back in April of 1989. Investigators say Pearsall was originally charged with murder, but the charges never went before a grand jury, and he was subsequently released. Fast forward to February of 2018, about 2.5 years ago, he was recharged with murder thanks to new evidence.
On April 23, 1989, German Ray Pearsall was accused of shooting 31-year-old Gino Tyrone Harper at an after-hours spot in Goldsboro, North Carolina. Mr. Pearsall was pulled over shortly thereafter while leaving the crime scene. The police found a handgun and brass knuckles on the seat next to him. He was arrested for DWI and carrying a concealed weapon. While being questioned at the police station, reports came in that Harper had died from his injuries. It has been said that police stated, "Forget about the DWI. The man that you shot has just died." Pearsall was ultimately charged with murder later that day. He was booked and given a $10,000 bond. Months later, he was indicted by the grand jury, and the trial date was set for April 1st, 1991. However, the case never went to trial. After 2 years of maneuvering by German's defense counsel and ineptitude and neglect by the Wayne County Prosecutor's Office, the case was dismissed on April 4th, 1991. The district attorney who signed the order never gave a reason for the dismissal. Days later, the victim's mother, Ms. Maddie Moy, paid the Wayne County District Attorney's Office a visit. She made the secretary aware of her displeasure of German being able to walk free. She in turn asked the secretary for a copy of all the files concerning the case. The secretary in response tried to set up a future appointment for Ms. Moy with district attorneys Don Jacobs and Claude Ferguson. Ms. Moy refused the appointments, believing they would just give her the runaround as they had done so many times before. The secretary answered that Mr. Jacobs was in an important meeting and couldn't be seen. She explained that if Ms. Moy would set up an appointment, then Jacobs would review the evidence and detail how the case was impossible to prosecute. She also told Ms. Moy that she could not have any copies of the files because the information was confidential. The secretary let Ms. Moore know the problems with proving that German shot her son with the intent to kill. She also explained an issue with matching the bullet with the gun. She confirmed that just because the bullet could have come from a gun in German's vehicle, that was not proof that Pearsall had intended to kill her son. Ms. Moore was not having any of that explanation. She left letting the secretary know how bad the justice system was. She also inferred how Pearsall was probably somewhere laughing, seeing how he had just got away with murder. Her last words walking out of the office that day was she was not through with the matter. Although Miss Moore would sadly pass away 10 years later, the words spoken in her physical body would soon manifest. In 2018, nearly 29 years after the crime, an investigation of the case was reopened by Detective James Sturgill. 2 years later, a family member of Gino Harper received a knock on the door. It was a detective alerting the family to the October 14, 2020 arrest of Mr. Gurman Ray Pearsall for the murder of their family member. Gurman was taken into custody by the U.S. Marshal Task Force in Goldsboro, North Carolina. This came as a release and a ray of hope to the family of finally receiving justice. But as you will see in the rest of this video, they are still facing the uphill battle of getting closure and a conviction for the accused. Originally given no bond, Gurman was eventually released on a $200,000 bond and other special conditions. Consequently, the bond was unsecured, meaning the normal 10% or $20,000 for a secured bond would not have to be paid. In lieu of the bond, Gurman would be released on an ankle monitoring system and a curfew to oversee his whereabouts. The reason for the release, according to the family, was due to concerns of the jail population in the midst of the COVID-19 epidemic. After a couple of years and much maneuvering and many motions by the defense, the case was eventually set for trial on March 10, 2023. However, despite the objections of the family, Mr. Gurman remains free and has yet to go to trial as of the day of this video. In the following parts of the video, we will explore the night's events that led to the death of Gino Tyrone Harper and the arrest of Gurman Ray Pearsall. We will also examine the Keystone Cop-like tactics of the Goldsboro Police Department and judicial system that led to the miscarriage of justice to the Harper family by letting a cold-blooded killer in Pearsall go free. Finally, we will analyze the court documents from the current case as Mr. Gurman's lawyers present their case for another dismissal, while the defendants of Harper continue their hope for a conviction. This case all started on a spring evening in 1989. If you're familiar with Goldsboro, North Carolina, there has never been a shortage of what we call liquor houses. A liquor house is a residence in which the owner sells 50 or $1 shots of liquor to friends, family, and community members. Usually there was music, dancing, food, cards, and a variety of other activities to accompany the drinking. In the late 1980s, one of the most popular spots was Doc Reed's. Doc Reed's was located in North End section of Goldsboro. It was at this residence where the incident occurred that led to the death of Gino Harper. According to eyewitnesses and family member accounts, both Gino and Gurman were in the liquor house that night. Apparently, the two got into an altercation after Gino tried to break up an argument between Gurman and Gurman's ex-wife. Pearsall evidently took exception to the interference and invited Gino outside to talk. Witnesses say the two men walked outside briefly. After a few moments, people in the house recorded hearing a shot. According to reports, Gurman shot Gino Harper in the leg. Gino in turn fled from the gunfire on foot, running to a nearby porch. It was said that he knocked on the door screaming and begging for help. However, the resident refused to come out and assist him for fear that the violence may be still nearby. Gino eventually bled out as the bullet severed his femoral artery. After shooting Gino, witnesses say that Gurman re-entered the liquor house, sat down at a table, and ordered a few more drinks. The police say they received a 911 call around 4 a.m. that someone had fired a gun between the intersections of George and Fussell Street. After the call, units were dispatched to the scene. Because Pearsall didn't leave immediately, police was arriving near the scene when he eventually decided to drive off. Officer Dennis Graham observed Gurman's car make a right on Fussell Street. He followed the car after seeing the car swerve and eventually hit the lights. After searching the car, the officer found a loaded firearm and brass knuckles on the seats next to Gurman. Also, a blood alcohol test determined Pearson to be intoxicated. Pearson was eventually arrested for suspicion of DWI and transported to the Wayne County Jail. While in custody, he was questioned about the situation at Doc Reed's. Eventually, word got back to the precinct that Harper had died due to the shooting. The detective informed Pearsall not to worry about the DWI charge because the person that he had shot had just died. Later that day, a warrant was issued for Gurman's arrest for the charge of first-degree murder. The warrant was executed by C.E. Boltonhouse. Gurman was originally given a $10,000 bail. He was also assigned or hired one of the best lawyers in the city of Goldsboro, John Duke of Duke and Brown. Duke was well known for his courtroom savvy and his effectiveness in defending his clients. True to form, he immediately went to work in finding or creating loopholes in the state's case. Despite Duke's efforts, in December of 1989, the grand jury returned a true bill of indictment for the charge of murder against Gurman Ray Pearsall. This act meant that there was enough evidence against Gurman to bring him to trial. The indictment was signed by Prosecutor Charles B. Vickery III and jury foreman Sheila Davis. Keep this fact in mind, as a later article would suggest that the reason the case was dismissed because it was never taken before a grand jury. As you see, this was an absolute lie. Nevertheless, the case was set for trial on April 1st, 1991. In January of 1991, Gurman's lawyer, John Duke, submitted a motion to suppress evidence pertaining to a statement that Gurman had made when he was arrested. Duke cited that Gurman's constitutional rights had been violated. His claims include that his client was not taken before a magistrate or being advised of his rights. He also pointed to the fact that Gurman was held for a long period of time, handcuffed all night, and questioned without counsel. He also asserted that his client was intimidated and frightened and now realized that he could have had legal counsel present at all of his proceedings. He claims that Gurman did not understand the gravity of the situation and would not have made a statement otherwise. Lastly, Duke stated that Gurman did not receive a probable cause hearing or copies of the statements made against him. The motion to suppress is a tactic used by several attorneys in preliminary hearings. The goal is to find fault in the way evidence was obtained or handled, or in the way the client was treated. To suppress the evidence means to make it inadmissible in court. In other words, the jury will never get to hear that part of the evidence. Apparently, Duke was questioning the validity of a statement written or verbalized by his client on the day of his arrest. Duke's claim of his client not being advised of his rights, questioned without a lawyer, mistreated, scared, and clueless of the situation are all grounds to make Gurman's statement invalid. The documents I received show no record of a statement, but because of Duke's motion, we must concur that a statement was obtained, and that statement may have indicated Gurman's guilt. The documents also fail to indicate whether this suppression of evidence was granted or not. However, due to the eventual dismissal of the case, there is a high probability that it was. If the motion was granted, that means that any incriminating statement made by Gurman would not have been presented in court or heard by the jurors. Unfortunately for the Harper family, the case never went to trial. While Duke was pulling out all the stops to damage the state's case, the prosecution was having trouble of its own without his interference. These following documents highlight many holes in the state's case that would later jeopardize a conviction, although the evidence against Gurman seemed foolproof. Several witnesses were ready to testify that Harper tried to break up a fight between Gurman and his ex-wife. Everyone at the liquor house saw the two men go outside and heard the gunshot shortly thereafter. After the shooting, Gurman was stopped in his car drunk with a loaded gun. A blood trail from where Harper eventually died led back to the bullet that went through Harper's leg, containing his DNA. The bullet was tested by a crime lab and found to have come from the gun in Gurman's car. An open and shut case, right? Well, as Denzel Washington most famously stated in the movie Training Day, it's not what you know, it's what you can prove. And in the case of Gino Harper and Gurman Pearsall, undeniable proof would not be enough. The chemical analysis that identified Harper's blood on the bullet was conducted by analyst L.D. Milks. Milks was later determined by an independent review conducted by the North Carolina Attorney General's office to have falsified reports on blood analysis on several occasions. This fact could be used by the defense to impeach or discredit Milks' findings and testimonies. The second wrench in the state's case was the prosecution's inability or unwillingness to return a key witness from Florida to testify in Goldsboro. Analyst Susan Komar was the individual who examined the bullet and the gun and determined that the bullet was probably fired from Gurman's gun. She also analyzed Harper's bloody clothing. Komar apparently relocated to Florida before the trial date and began working for law enforcement there. A source from the district attorney's office would later indicate that Komar left the state under adverse circumstances. The state deliberately neglected to secure Komar's return to back up her findings with her expert testimony. These two critical mishaps by the state were probably the reason that Gurman was set free. A note found in the document substantiates that notion. It stated that the case was dismissed because of the problem of matching the bullet with the gun and the difficulty of getting Susan Komar back from Florida to testify. The person in the note also recalled a conversation. I questioned Jim about the case because he thought he would try the case at one time, and he felt it was non-suited. The DA at that time also cited, Claude admits that Pearsall is really a person that needs to be punished, but he probably won't be able to get it. By get it, the person meant a conviction. Non-suited in legal terms means a case that is dismissed because the plaintiff is unable to make an adequate showing of evidence or is unwilling to move forward with the case. The question that begs an answer is, if everyone in the prosecutor knew Gurman was guilty, then why didn't they exhaust all resources to get Ms. Komar back to court and to get the DNA analysis done by a more credible witness? Why would the prosecutors be unwilling to move forward with the case? With these questions unanswered, on April 4th, 1991, the charges against Gurman were dismissed and he was allowed to walk free. And as you can see from the official document, no reason was ever given for the dismissal. With the mountain of overwhelming evidence, Gurman Pearsall literally got away with murder. That is, until the reopening of the investigation by Detective Sturgill and the subsequent arrest in 2020. A statement made by Goldsboro Police to CBS 17 in an article detailing the arrest raised more questions about the state's integrity in prosecuting Gurman nearly 30 years earlier. The Goldsboro police stated the charges were never taken before the grand jury, so that is why Gurman was never prosecuted. However, as this document shows, the grand jury released a true bill of indictment on December the 17th, 1989. There is no way that an indictment can be issued without charges being submitted to the grand jury. So the question is, why would the state blatantly lie about Gurman not being indicted? Could it be that the state was trying to save face and cover up the fact that they originally botched the case and miscarried justice? Nevertheless, Gurman was now in custody, much to the pleasure of Harper's family. However, he was released less than a month after arrested on a $200,000 unsecured bond, meaning once again, he didn't have to pay the required 10% or the $20,000 to be released. In essence, he was allowed to walk free. However, as mentioned before, he was subjected to an ankle monitor, house arrest, and various other conditions. Again, I question, why was the Wayne County judicial system being so lenient on an accused murderer? Just as before, a motion to dismiss the charges was filed shortly after his arrest. However, that motion was denied on October 29, 2020, 1 week before Gurman was released. The denial was executed by Judge Charles P. Gaylor III, father of current Goldsboro City Mayor Charles P. Gaylor IV. Shortly after this, another true bill of indictment was handed down by the grand jury on November the 3rd, 2020. The indictment was witnessed by investigator James Sturgill, who was the catalyst who reopened the case. Since the arrest, various motions have been filed on behalf of the defendant. His new attorney, Christine Malumphy, would follow in the footsteps of Gurman counsel from 30 years earlier, Mr. John Duke. She immediately began citing reasons why the case should be dismissed. On November the 18th, 2022, she filed a motion to dismiss the case due to pre-indictment delay. Essentially, she was saying that because nearly 30 years has passed before he was indicted again for the charge. In the motion, she cited several reasons. In paragraph 6, she brings up the misdeeds of Milks, who analyzed the blood on the bullet but was found to have falsified documents on several occasions. In paragraph 9, she recounts the problem that the state had in getting Comer back from Florida to testify. Comar was the analyst who performed the ballistic test on the gun and the bullet. She also cited the conversation of the DA, knowing Pearsall was guilty, but not being able to get a conviction. The attorney also focused on the fact that the DNA test that showed the blood on the bullet was Harper's, and the bullet could have come from Pearsall's gun. She emphasized that Comar's test has been reconstructed and the results remain the same. So the lawyer claims that since no new evidence has been found in 29 years, several witnesses have passed away, and even the previous defense counsel has died. She asserts that this counsel would have been able to provide information relevant to the defense. She lastly claims the reason for the dismissal was because the state failed to produce the witness from Florida, and retrying the case much later would be an act of bad faith by the prosecution. In paragraphs 20 and 21, the lawyer places all the blame on the state. Multiple witnesses have died, memories have faded, and documents have been lost. Most damaging is the motion's acknowledgement of the state's malignant neglect of the original case. They alluded to the fact that the state could have retried this case many times over and remedied the issues that the DA had with the DNA and the ballistics tests. Instead, they ignored the case for years until many witnesses were deceased, files were destroyed and court proceedings were unable to be recalled. In the summary of the motion, Malafry asked that the court dismiss the case with prejudice and consider all the previous motions that were filed. I must admit that the lawyer makes great points in this argument. The mere fact of the previous dismissal with no reasons given and the evidence of the state's neglect to retry the case for nearly 30 years is excellent grounds to stand on. However, the clear-cut evidence of a bullet from the gun of a man who was leaving the scene of a murder that had the deceased's blood on it is enough for any jury to convict in this day and age, or 30 years ago. Another motion was filed after this one by the defense to obtain files on 3 of the state's key witnesses: Milks, the DNA analyst, Komar, the firearm analyst, and Thomas Clark, the medical examiner. These files will serve to prove or disprove the credibility of the witnesses who were expected to testify and whose work is connected to the state's evidence. In supporting this motion, Malafry cites Komar's alleged leaving the state under adverse circumstances, Milk's falsifying documents, and Clark's resignation from a position in Tacoma, Washington, after being accused of being dishonest and unobjective in his work. This motion demanded files from the NCSBI, the State Crime Lab, the Attorney General's Office, and the State Medical Examiner's Office. These files will be used to question the credibility of the person's evidence and testimony. The court records failed to show if any of these motions were denied or granted. However, since the case is still open, we can assume these motions were accepted. And how do we know that the case is still open? On March 10, 2023, there was an order submitted by Judge William Bland for the matter to go to trial on March 11, 2024. According to family members, the case has been continued since 2020. As we can see from all the motions, there is much legal maneuvering by the defense to make the case linger and prolong. The family held on to their hopes for justice for over a year, only for March the 11th, 2024 to come and go without the start of a trial. The family of Harper was given no reason as to why the case was continued once again. However, 8 days after the trial was to start, the defense filed another series of motions to again delay the case and hamper the state's ability to prosecute. Previous documents show that the case was set for trial on April the 17th, 2023, but was continued due to the DA's health conditions. Then it was set for October 23rd, 2023. However, the defense claims that they had to attend another case that took up all of their time, and they needed additional time in order to file motions. They stated that they would have the motions ready by October the 31st and be ready to present them by December. Apparently, this is the reason that the case was continued on March the 11th, 2024. Evidently, the defense didn't make their December deadline. On March 19th, 3 more motions were filed. The most important motion was to suppress the gun and the items that were seized from Gurman's car on the night of the murder. The motion stated that Pearsall's mere proximity to the crime scene was not justification for the officer to stop him. Without any indication of criminal activity, it was unreasonable to assume that he committed a crime. Therefore, if the stop was unlawful, then the item seized, namely the gun, would be considered fruit of the poisonous tree. Therefore, the motion asked that the gun not be included in evidence. Another motion was for the motion of discovery and the motion to compel. This is the defense's request for all 911 calls, photographs of the scene, Notes written by Officer Gillis, Simmons, Melvin, and Graham. Police reports and other evidence that the state intended to present at trial. The defense knows that this request will further increase the delay of the case. The most egregious motion as far as the family is concerned is the motion to modify Pearsall's release conditions. The defense asked the court to remove Gurman from the house arrest and the electronic monitoring system. They cited his lifelong residency in Goldsboro, as well as his job at the chicken plant, as reasons to be released. He also complained about his ability to visit family and friends as frequently as he wanted to. The family countered, saying that they couldn't see their family member, even if they wanted to. These documents that you have seen are the most recent documents in file 20 CRS 53432. There is no indication that any of these motions were granted or not. Additionally, as of June 2nd, 2024, there is no other order setting the case for trial. So over 35 years after the crime and almost 4 years since the reopening of the case, Harper's family has yet to receive any semblance of justice. It is obvious from the many mishaps in this case that the Wayne County District Attorney's Office failed miserably. Not getting the ballistics analyst back from Florida was gross negligence on their part. Not getting more DNA tests done after the discovery of Milk's indiscretion left evidence questionable. Waiting over 30 years to reinvestigate the matter is outright unacceptable. As the defense pointed out, most of the witnesses are either dead, out of the area, or unable to remember. The defense continues to exploit this fact by filing motion after motion. The family of Harper, on the other hand, feels that the state is just waiting for Mr. Pearsall to die. Keep in mind that he is 70 years old. Nevertheless, the family keeps the faith that justice will prevail and the killer of their relative will finally get punished. All right, so the case of Gurman Ray Pearsall and his participation within the murder of Gino Tyrone Harper illustrates all that is wrong with the American judicial system, and more specifically, the Wayne County judicial system. Overwhelming evidence proved that this man was responsible for the death, cold-blooded murder of another man. Our witnesses were ready to testify to that fact. DNA evidence confirmed that fact. Ballistic tests confirmed that fact. And of course, he was stopped, leaving the scene with a handgun and brass knuckles. Nevertheless, after his arrest, the Wayne County District Attorney's Office let legal maneuvering and posturing affect their ability to convict Mr. Pearsall. Justice is not using all of the legal loopholes in order to get a person that everyone know is guilty off. As you saw in the video, one of the district attorneys admitted that Pearsall need to be punished, but they probably wouldn't get a conviction. Why? All because they didn't want to spend the $200, $300, $400, or $500 to ensure that Susan Comar, the one who performed the ballistic test that proved the bullets came from Gurman's gun, they did not want to spend the necessary resources in order to get her back to court. Also, when they found out that the guy who did the DNA test was confirmed to be falsifying documents, only thing they had to do was get another test done. And so the mere fact that the Wayne County Prosecutorial Office did not take the necessary steps to ensure that a guilty man get punished, that makes them culpable in this matter. And the racial component can't be ignored. Here you have two black men in a southeastern North Carolina town, which has a deep-rooted history of racism. This shows me that they did not take Mr. Harper's death as serious as it would have been another person of another race. There is no reason why those two things couldn't have been done to make sure that Mr. Pearsall was convicted. And what's even more disturbing, as you see from the news articles that was posted, and the news articles from the News Argus, December the 12th, 1989, says that German Ray Pearsall was indicted. An indictment was handed down by the grand jury of Wayne County for the charge of murder. However, as you see in the WITN article, you can look up the CBS article. Only thing you have to type in is German Ray Pearsall, Goldsboro, North Carolina, and you will see how the Goldsboro Police Department said that German was released because charges were never brought before the grand jury. That is an outright lie. And the fact that it has been almost 4 years now and Mr. Pearsall has not yet went to trial is a further slap in the face to the Harper family and to the surviving family, the Moore family as well. And so this is a plea. This is an order, a decree to the current Wayne County Prosecutorial Office, namely District Attorney Matthew Delbridge, also the judge who is sitting on this case, Judge Bland. This is a plea. This is a exhortation for you guys to do the right thing in this matter. Now, maybe Mr. Pearsall has lived a crime-free life since then, but that does not discount the fact that this family has been denied justice for over 35 years. And so I hope this information was put together in a way that you can see the improprieties of the judicial system here in America, where lawyers can use all types of legal strategies, techniques, loopholes to ensure that justice is not served. That may be the protocol for all of these things to have taken place, for them not to get a conviction, but that is not justice. What you are witnessing and what you have witnessed, what you just saw in that video, is the perversion of justice. And I hope that the Moore family will make sure to be diligent, vigilant, persistent, consistent in their pursuit of justice for their family member, Mr. Gino Tyrone Harper. Peace and blessings.